So, welcome everybody, whether you are watching live or you are watching the recording, you are very welcome to take part in Operation Respond 2026. So, if this is the first time you've joined us, welcome. If you're a returner, you're in year three. And I'm really glad to see you back if you are a returner. Now in its third year, Operation Respond was named quite carefully, really, on the back of what we were told in sort of November, December 2023 was going to be a particularly challenging 2024. And I think the idea being that if we were to take the word respond and react and respond to the challenge ahead rather than react to it during the year to come, we were going to be much better off. And it's always something I've held true in management and leadership training, that as a leader, we should respond and not react. Sometimes easier said than done. The distance between our lips and our brains, for some of us, isn't as long as you might want it to be. But if we do respond, we tend to do our best work. And for me, this year is all around the word mindset. So I've had words of the year before. Words like clarity, I think that might have been last year's word, or if not, it was the year before's. I've had words before that have meant something and spoke to me, but mindset very much speaks to me this year. And I believe that those of us with the right mindset are going to find this year not necessarily easy, but easier than those of us with a different mindset, one where we let in all of these things that others will tell us that are going to distract us from doing our best work. So it's not a strategy word. It's not about leadership or strategy. It's not about systems. It's about mindset and resilience, really. And I really do wish for Generation Z, more resilience in the year ahead, because I definitely think, being Generation X, we've been trained in resilience. Every year is difficult, isn't it? Every year brings challenges, unpredictability, obstacles, and 2026 is going to be absolutely no different. The only thing that's going to be different, if we want it to be, is how we meet those obstacles, challenges, and difficulties. And I think those leaders who are always on edge, always, you sit and read them yourself in Facebook groups, I'm sure, where people are sort of saying that, their bosses will tell them that if they were to leave to go and pick up their child to take them to hospital, then they might not bother coming back because, they'll be out of ratio and they'll breach contract, and all of this nonsense. And, I think that those leaders who are running those settings must be constantly on edge and constantly feel that they've got to control people's minds and bodies. And that's just not going to work, is it? So for me, this week is about giving you some anchors. I've surrounded myself this week with, some great speakers that have got huge amounts of value to share with you this week. We're going to cover a variety of topics over the 4 nights. I hope you find it incredibly useful, and it helps feed in your mindset of, let's plan, let's have a purpose for this year. Let's plan so that we don't react, we do respond. Let's not be as frantic as others might tell us we need to be. Panic, my nervous system sometimes needs to be told, we are not being chased by saber-toothed tigers here, everybody. We need to just, recognise this for what it is. This is a small blip. Things will return to normal. We've got to treat energy with respect, the respect it deserves in 2026. And, we've got to spend that resource energy wisely, I feel. And, taking a pause to make a decision is going to be a big thing, I think, for many of us. Taking some time to be calm and to sort of take ourselves away from the noise and the silliness to really think carefully about what we want to do. And remembering that not everything needs to be fixed today, and not everything will be fixed tonight on tonight's call, and not everything will be fixed this week. But if we are all in this together, then we will respond to 2026 and the obstacles and the challenges and the difficulties that we will face, because we always do. So my session for you tonight is on employment law. I'm going to give you an update on all the things that are going to change this year, and how we want you to prepare as early years employers to the challenges that employment law changes will bring to you over the next 12 months. So without further ado, I'm going to get cracking with this, because then we have perhaps a little bit of time at the end to open up for any questions for those of you that are on the live. So for those of you that know us here at Redwing, this is a team shot from probably just about 12 months ago today, actually, maybe a bit more later, from the year before. We're definitely a bigger team. As of today, I think we're 13 in the team. So as you can see, we are not all here. But yeah, we're a good team, we're a good sized team, and we're here to support you with any HR and employment law queries that come your way. What we're going to cover this evening is everything that the Employment Rights Act, as it's now called, is going to throw at us over the next 12 to 18 months. And I'm going to take it in order. So I'm going to deal with the issues that are coming soon in the beginning part of the session, and those that are still some time away towards the end. And as I say, what would be really useful is to have a little bit of time for any questions that you might have regarding employment law and HR, even if it's not relating to the Employment Rights Bill. Don't feel you can't ask tonight. So where are we since Labour said that they wanted to introduce the biggest employment rights legislation change in a generation when they were elected? So they were elected in July 2024, and they announced that there were going to be an employment rights bill, as I said they would do, within 100 days. The journey through Parliament, I think we'd all agree, hasn't been a smooth journey between the House of Lords and the House of Commons. Back in October was when the bill was meant to be in the House of Commons to be approved. It didn't go to plan, hence the word whoops. And then we entered an official period between the House of Commons and the House of Lords called ping pong, and officially called ping pong at that. By the 27th of November, we had the U-turn. So it seems like everybody gets a U-turn these days. Well, we had a U-turn on day one rights for unfair dismissal. So the government conceded that just wasn't going to get past the objections that were being raised. So it was a little win, really, for business. It received royal assent in mid-December, and the first parts of the Employment Rights Act come into fruition 2 months after royal assent. So middle of December, first month is middle of January, middle of February. So from mid-February, there will be elements of the Employment Rights Act that are in place, if you like. The first parts become law. So it's been quite a journey from the moment it was obviously first suggested to us. If it was part of them, it was obviously a lot of it was part of the manifesto. Angela Rayner was all over it in terms of her publications about what she wanted to do to see Labour offering a different level of support for employees and workers. And we're now quite a time on from there. So if you take the journey in terms of a timeline, so we've had royal assent mid-December. We're going to get some big changes on SSP, and I've really only included the biggies on this timeline, but there are lots of smaller things. I'm not going to say less big, but they're not as big as these biggies. We've got SSP coming in a few weeks, which I'm sure you'll have questions about. Be reassured that we're giving a lot of thought to SSP currently at our end as to what we can provide you as a resource to help you understand what this is going to mean. Fire and rehire, again, big area for Labour in terms of their manifesto, that they wanted to prevent another P&O ferries and what happens there. And so very much a headline for them was to ban fire and rehire, prevent this happening again to employees and workers. And then obviously unfair dismissal change, again, a real headline grabber. And we believe that this will come into fruition in a year's time, in January 2027. But because it is in January 2027, it will impact those that you've hired this month, which you probably hired last week. And it'll impact those that you start in July, because obviously if you start somebody in July, they'll only need 6 months service before January 27, before they will then have the 6 month service the government says that going forward employees need to have in order to bring a claim for unfair dismissal. So this is going to really shake up a lot of employment advice that's given, because obviously At the moment, we ask a lot of questions about how much service someone has in terms of understanding where they would be in terms of unfair dismissal claims and the 2-year rule. That's all going to change in 12 months' time. So let's talk about what's coming in April. Let's get started with spring bulbs and April. So we've got some trade union changes coming up in April. Now, you may be sat there thinking, as a private sector employer, do I need to really worry about the trade union movement and about Labour's desire for more and more people to be members of unions and for union membership to actually be the norm? Well, actually, you do. Big businesses, big private business, big public businesses, big public sector employers have always concerned themselves with trade union membership because it's always been an issue for them. And I still think that there are many reasons why these changes aren't targeted at small businesses, small private businesses, but are actually targeted at large private sector businesses that have so far resisted union membership and union recognition in their workplaces. So, I would say somewhere like Amazon, that we would have in our town, an Amazon depot, they would be the sort of people that may well be up against it when it comes to trade unions wanting to get access to their staff and workers in order to attract them to join their union and to then put pressure on Amazon to negotiate and to recognise the union involved. So currently, it's quite difficult for unions who are, balloting employees on industrial action because of the amount of time that they have to give in order to give notice of a strike. And so what Labour have done with the Employment Rights Act is to, if you like, reduce some of the timelines to make it less difficult for unions to call strikes. So from April, unions will only need to give 10 days notice of strike action, not 14, so it's reduced. The protection against dismissal for those taking industrial action beyond the first 12 weeks of a strike is now in place. So again, that's grown because it was protecting somebody for longer now, so it's more beneficial to members who may well be concerned about taking industrial action as to whether they might be protected. We feel that unions will feel stronger for all of these reasons, and statutory recognition will be easier from April this year. We will be providing you with more information about what to expect about unions who will approach nurseries. Now, we know obviously you have a front door, so you've always been able to be approached, whether it be by the HMRC or if it now be by unions. Again, I think it will be the large chains that they'll go after approaching first before the smaller businesses, but they will definitely look to get members from the sectors such as care, childcare, social care, in order to be able to grow their membership. Anywhere where there's lower paid workers with higher responsibilities, we can expect to see unions looking to sweep up and to get new members. The issue being that union membership is obviously a cost, and for many people in 2026, anything to reduce costs is a good thing, and anything that increases their costs has to be evaluated and seen whether it is worthwhile the fee, worthwhile the cost. Not saying that people won't join unions, but I don't think it's as straightforward as as governments might think it to be, in just saying, well, make people join a union or suggest they join a union and they will. I think there's more to it than that as to whether it's going to work in the way that they perceive it might. So more about unions later. From April, we'll have the Fair Work Agency. Now, this is a huge introduction for employers in the UK. We've never before had an organisation whose job it is to bring claims and to put pressure on employers on behalf of employees and workers. Now, at the moment, if you were to feel that you've been underpaid the national minimum wage, you would obviously advise your employer that you believe you've been underpaid. You would go through the process of letting your employer know that that's what you believe has happened. You might get support from ACAS on that journey, and ultimately you would report your employer to the HMRC, and the HMRC would then help you to find out whether you have been underpaid, and if you have, then obviously the HMRCs like to find other people in your situation that have as well, and this is where employers get name and shamed on HMRC lists. Employers have to repay obviously the amount that has been underpaid. There can also be fines on top. And obviously your employer has been shamed into their breach, whether it be a breach they determined to do, or what is more common, which is an unintended breach because of not of an awareness of what goes on, but perhaps by something that they thought that was perfectly acceptable, not linked to national minimum wage. So we've always had people's ability to bring claims in these areas, but we've now going to have an agency that was going to bring these people to account on behalf of other people. Now imagine a situation where you don't want to bring a claim against your employer for statutory sick pay not being paid correctly, or holiday pay not being correctly paid. You don't want to bring that claim, and the National Fair Work Agency takes this on your behalf. You will then receive the benefit of any compensation and award that they can get through the tribunal system, and they will be looking to make a point. So again, I don't think the Fair Work Agency, like I say with the unions, I don't think they're looking at smaller private businesses in their radar. I think they are looking at larger private businesses to make an example of. And I think what's going to be really uncomfortable is, people who are not used to dealing with, and nobody would be used to dealing with the Fair Work Agency because it's brand new. But you imagine having, a third party with power coming after you on behalf of your workers to get a solution. That's not going to be a pleasurable experience for any HR team that's on the receiving end of those calls. So yeah, I think it will be used strategically. I think they've only got a finite budget. They're not going to come after everybody. They're not going to bring claims for everybody, but I think maybe they'll increase the amount of information shared, and maybe ACAS will start to share some of its duties to support employment practices with the Fair Work Agency, so that there is a division of labour, if you like, because we all know that ACAS is swamped. Collective redundancy is an area that's changing. So again, probably not something you need to worry too much about. But if you are thinking about redundancies in 2026 and beyond, bear in mind that the rules have changed. So a collective redundancy, so more than 20 employees affected, we now have to think about, obviously, what happens if this goes wrong. Now, it's very uncommon for an employer to be found to have failed collective redundancy requirements. And that's because most employers who are looking to make redundant more than 20 people sensibly get help and advice before they press the button. However, some people don't, and they rush things and they think they know best. And at the moment, the compensation has gone from, is 90 days pay, and that will go up to 180 days pay. So if you can imagine 3 months pay at the moment, if you fail to follow collective redundancy consultation correctly, 6 months in the future. And that's actually for every member of staff that's caught up in the collective redundancy, whether they were bothered about it or not. So that is a very expensive bill that could be racked up if you rush to redundancy in 2026 and beyond. So, again, always advise it. If you're thinking of a redundancy, whether you're thinking of one role that you feel that you no longer can justify in your business, or you're thinking of closing a place of work, which is another very typical redundancy. You might keep another place but close one place. If you're thinking of removing a level of roles within your organisation and perhaps replacing it with something different, perhaps with more responsibility, with different responsibilities and terms and conditions, then think about getting advice about that redundancy before you press the button. Because I can't tell you how difficult it is in a redundancy exercise to fix things that have already been done incorrectly. It is far easier to design in good practice than it is to try and course correct when something's gone wrong. So we would always suggest to you to reach out and get help when it's in your mind before you've pressed the button. And never is that more true now that we've got changes to rules on the penalties if you get it wrong. Big one that's coming in April is paid sick leave. And, I do hope those that make Xero, QuickBooks, Sage are squirreling away in the back garden. I've seen a lot of squirrels this weekend, squirreling away, sorting out our accounts and payroll software so that we will be able to manage SSP from April 2026 and all of the changes that are coming. So at the moment, If you are off sick in January 2026, an odd absence, so if you didn't go in work today, but you went in work tomorrow, if your employment contract says that you receive SS pay, you would receive nothing for today because you have to have 4 days of absence. You have to have 3 waiting days to receive money from day 4 when an absence is occurring that's going to be subject to SSP, and you have to earn over the lower earnings threshold, which is 123 or £5 a week. I can never remember which way it is. I think it's 123. So the government has decided that this must change. So it wanted it to be a day one right to SSP, believing that this was going to prevent people going to work who were unfit for work. So the government has got this view that people go to work and spread germs because they can't afford to be off on SSP. SSP's £118 a week plus some shrapnel. The idea that people will now obviously stay at home for an odd day's pay SSP. So if you get £118.75 for a week's pay, a day's pay is not £118.75, as you can imagine. It's a fifth of that if you work 5 days a week. The idea that people will now obviously stay at home, I think, is naive to think that it's going to improve the wellness of the UK because people will stay at home and get the rest and recuperation they need. What's actually going to happen is people are going to take odd days sick and get some pay where perhaps they previously would have gone to work and got on with it. Yeah. And this will totally change the behaviour of people who do not have to receive any money to want to obviously take as much sick pay as they can. And there are people out there that feel that way. Obviously, if somebody hasn't got bills to pay, hasn't got mortgages and rent payments to make, receiving something rather than nothing is better. And so therefore, I'm afraid some people will now take odd days absence and receive something. And if they don't earn the lower earnings limit, then the government has said that it will be 80%, 80% of someone's average weekly pay. Now, this is a huge amount. So if you've got a £90 a week person, maybe they work in an out of school club for you, they work a few hours a night, perhaps not every night in the week, £90 of wages. They previously wouldn't have had any SSP from yourself. If they were off sick, they would have been given an SSP1 form, which would have ticked the box to say, I'm afraid we can't pay you SSP because your earnings are not sufficient. They will now get 80%, and your payroll software, your Xero, your Sage, your QuickBooks will have to be able to calculate that for you because the government has said that the lower earnings threshold should be removed as a requirement and 80% of someone's average weekly pay should be used instead. Now, think about that with casuals and people who are on 0-hour contracts of employment, and they're on those contracts because clearly they are, somebody for whom you want to do safe recruitment once and have them in when you need them and not when you don't. This is going to be hugely problematic for calculation purposes. We're going to need to amend contracts to say that obviously eligibility to SSP has changed. We're going to need to change your sickness absence policies. If they already say SSP is paid in line with statutory provision, then fair enough. But if they don't, we're going to need to be specific. So policies will have to be updated, absence management sections of handbooks will have to be updated, and contracts will have to be updated. But I do want to stress, I think we'll see a behaviour change when it comes to odd day absences. So how you approach that as an employer, I would ask you to have a think about. There's going to be more resources from people like ourselves to help you to think about what might be best to try and reduce the impact of this on short-term absenteeism, because we don't want to see it going up. But I think it will change people's mindset if they know they'll get something rather than nothing. And with our lowest paid people in society now benefiting from some statutory sick pay, albeit 80% of their normal average weekly wage, as I say, 80% SSP of your normal wages may not be that far different to your normal wages if you're already in a low paid job and you don't have great wages. But if you're able to obviously claim those. And remember, you can claim SSP off more than one employer. So you could have a portfolio of 2 or 3 employers all paying you a small sum, and that adds up to what meets your needs. And you take time off from all of them, and they all pay you SSP based on 80% of your average working week. Very, very difficult to manage. Paternity and parental leave is changing. I know lots of people are announcing they're expecting babies this year. I should really change this to say that, we're expecting a puppy next month because that's our new baby. I have to say, I think I've spent more on Dougie than I did on James. Frank asked me this last week whether I was going to use a sling, and I pointed out that I didn't use a sling with James, so I could hardly use it with Dougie. Enough about that. So, paternity. So this isn't a hugely taken up right in the UK, very low take up. Paternity leave and paternity pay isn't a very great sum. Paternity pay is the same level as SMP. So it is very low take up. And I don't think anything the government is doing with this, making it a day one right, is going to change that. Now, I'd like to be really super confident to you and say that paternity leave will become a day one right from April this year, but the right to paternity pay still requires service. However, as of 12 hours ago, there was some confusion as to whether SPP may also now be paid out to somebody who doesn't have any service as well as their right to take paternity leave. And again, would have liked to have got to 5 o'clock and that answer to be definitive. We think at the moment that paternity leave as a right will not require service, but paternity pay will. But watch this space. It could well be that they change it both ways. Paternity leave still requires someone to walk into a new employer and to give notice that they wish to take paternity leave. So it's not as if you're going to have a situation where you hire somebody and they tell you that they are the partner of somebody about to give birth and that they wish to be off from Friday. That isn't going to happen. You still have to give notice. But if it is going to be paternity pay as well as paternity leave, then this is another cost that small business has to find. And therefore, it will be open to abuse by some people if they feel they can. The second element of this that's going to change from April is parental leave. At the moment, again, you have to have service to be able to take parental leave, and the government has said that they want it to be a day one right. Now, the reason why we have not seen a huge amount of parental leave is one, that it is unpaid, and B, you only get 18 weeks in the first 18 years of a child's life. And therefore, if you've moved jobs, which many people do these days, it's more common to move jobs than ever before. Most employers have a situation where they see high labour turnover and low levels of service in their workforce. So therefore, you may have already used your parental leave somewhere else. Now, when parental leave was first introduced, suggested to employers that you might want to ask about parental leave as part of the employment process, as part of perhaps the referencing process. These days, very difficult to get information about other things in the referencing process. So I can't imagine employers are going to want to share records on parental leave. But I do think that when it becomes a day one right in April, more people might decide to take a job they can't do. So imagine a situation where someone takes a all year round job when they can only work term time only. So they take a job they can't do and immediately submit a request for parental leave. And the government wants it obviously to be far more difficult for employers to say no, whilst we still can. They want it to be more difficult. They're doing that with flexible working. So, in terms of abuse of the system, I think we'll see more abuses. Just as I said about SSP having a behaviour change, I think parental leave may well have a behaviour change as well. And that would be not what we want. It's not something that we're looking to happen. But I'm afraid people might see this as a way of maintaining employment, because obviously to say you're on unpaid leave doesn't necessarily sound as bad as I can't do those weeks, so therefore I'll be off. Can I request that I have some time off that's authorised unpaid leave? Parental leave, as I say, you've always been able to say no to, and you will still be able to say no to it. You'll just have to follow the instructions and follow the process and make sure that you give the person who's requesting the parental leave an alternative at the time you're saying no. That's always been the case. But making sure you go through those hoops and that you obviously protect someone's right to request parental leave and to take it where possible is going to be super, super important. So this change in paternity leave, possibly paternity pay and parental leave, is going to result in new policies being issued. Parental leave is, if you like, a rubbish name because we have shared parental leave as well. Now, shared parental leave is more like shared maternity leave. It's where the partners that are going to be responsible for that baby, one of them having the baby or adopt through adoption, the partners that are having the baby together, they can share the amount of leave that they have between them. And obviously, subject to risk assessments and controls, that does happen. And many people, not huge numbers, but many people do take their maternity leave in a shared fashion. Parental leave is really there for when you need to care for the child and you can't be in work. So it could be that your care arrangements have broken down. You maybe have a situation that I can recall where a nursery had an employee whose child was cared for by a grandmother. Grandmother was going to be off her feet for 6 weeks following surgery. So the employee made a request to be off for a certain number of weeks whilst her mum was off her feet in order to provide childcare to her own children. And that's, perfectly reasonable and perfectly something that an employer can weigh up as to whether they can accommodate on those dates or whether they have to defer. I've also known people request parental leave to take extended holidays overseas, so to be away from the country but caring for their child whilst they're away. I've known people make those requests as well. These are all strategies that for some people, they never see very much of, but for others, it's another way for people who want to maintain employment but don't want to be there all year round, have another tool in their toolbox to make pressure on their employer to allow them to do what they want to do. Let's put it that way. And, whilst I'm massively in favour of unpaid ordinary parental leave, if it enables somebody to look after their children, if you're running a business, this is incredibly difficult to balance. And so I've got compassion for both sides. And I do think it's going to be quite problematic if we see a huge increase in uptake in parental leave in the UK. Mentioned about P&O ferries and Labour being very, very, very keen that what happened with P&O ferries where the workforce was fired and then obviously replaced by overseas workers on the same day never happens again. However, what government is proposing to change with regard to the Employment Rights Act isn't going to stop P&O ferries ever happening again, but it will make it very difficult to change someone's terms and conditions. Now, the idea of fire and rehire is the idea that some people are dismissed and rehired on less favourable terms. And the government quite naturally feels that that's, been abused by employers, big employers in the past, and they want to see an end to that loopholes being found and people getting through this in the future. So it's not that we don't recognise where this is coming from, it's that we don't recognise their solution as solving this problem. I think that's probably the best way to put it. So the Employment Rights Act is going to mean that it's automatically unfair if you dismiss somebody for refusing contract variations. So we're going to have to think differently about how we manage changes to terms and conditions. So if you have got plans to vary people's terms and conditions, we need to do it before the autumn. That's the bottom line. If you've got a element to someone's terms and conditions that no longer makes sense, you cannot kick the can down the road. You've got to pick it up now and say, right, what's our plan with this? Are we prepared to, force through this change? Which, many employers have always taken the view that they might try to vary terms and conditions, but they'll never be prepared to force it through. Other employers will say, yes, we absolutely have to have this happen. And whatever it takes, this will have to be the change that we achieve. We need this to happen in the business. So, if you are operating terms and conditions with no variation clause in your contracts, in your handbooks, we would suggest that you do that now. I don't think that's going to be the panacea that people might think it is, that it's going to fix everything, because I don't think it will. But I do think it's a helpful step in the right direction. So from October, so from the autumn, varying things can be very difficult. So what can we vary that's outside of it? So a place of work. So requiring somebody to move from working in one location to another location potentially will be outside of the automatic unfair dismissal regulations. Changing the job titles, job duties. Obviously, I would hope you've got job descriptions and that they are specified in your terms and conditions, that they are not contractual, not part of the contract of employment, and can be amended as needed to meet the needs of the business. Job title changes will not be something that you will run the risk of an automatic unfair dismissal for. It will be fine to change notice periods. So again, probably one of the common areas where somebody might say, look, we are wanting to, change this person's terms and conditions. We need a longer notice period from them, given what's happening in the labour market, what's changing, or we need to offer shorter notice periods because we can no longer afford what we've previously had as a long notice period from the company to the employee. So those are going to be absolutely fine, as will restrictive covenants. So this is important because obviously things may change, technological advances may change and mean that restricted covenants that didn't make sense in the past may need to be introduced in the future. So it's good that we've got a few things that are outside of it. What's not going to be outside of it will be things like holiday entitlement, pay, bonuses, sick pay, those sort of things are going to be within the scope. And obviously they do count for a lot of the variations that people do. So please, can we plan to vary terms and conditions before any of this comes in? So regardless of whether your planned variation falls on one list or the other, can we please try and do it before for October and autumn this year? Because you're going to want to have that breathing space of it being under the current rules, not the new rules from October. If we have got some runway, let's explore alternatives, which might well be using the idea of redundancy. And that sounds a bit strange, doesn't it? But if we're saying to somebody, look, we might need to change your terms and conditions, otherwise we might need to consider a redundancy exercise, then we're not talking about varying terms and conditions as much as the job changes and a redundancy being a risk. And that could be safer than just doing a basic variation exercise and consulting with somebody about varying their terms and conditions. Sounds a bit odd, but that's where we believe it to be. And we can consider, really, really, truly consider this. And I think it's important for many aspects of what's happening in the next few years with the Employment Rights Act is, please, can we write down the evidence of why we're making the decisions, whether it be, and this is off topic, but your decision to suspend somebody, write it down. Your decision, can't even get my teeth in now. Your decision not to interview a particular witness, write it down. Your decision to ignore a piece of evidence in investigation, write it down. If you've written it down as if one day you might be in a tribunal and asked why, and you've got a piece of paper that you can say, if you turn to page 39, you'll see a note I made to myself at the time. That is going to be a far stronger piece of evidence than you saying, I think, I thought, I did, I didn't. Yeah. So very important to evidence your variation journey to strengthen your case. If you've decided that the business needs X, then write it down, take notes in minutes, make decisions in writing. Do not do yourself the favor that your future self will thank you for, that you wrote it down as a business case at the time. So important. For variations of terms and conditions, for decisions to make roles redundant, write it down so that you've got it to refer to in the future. Write down the business case now, because then when someone's asking you to show why it was fair, you've got information that you can refer to them and say, this is why it was fair. This is what was going on at the time. This is what we thought at the time. This is what we did. So that'll get us through the next 12 months. But what's beyond that? 2027, January the 1st, we're expecting that to be the date that you only need 6 months notice, 6 months service for an unfair dismissal claim. Currently, you need 2 years. It's going to 6 months. It was going to be day one rights. We'll take it as a small win that the U-turn the government performed on this happened. But 6 months is no months, really. It's such a short period of time. People are barely out of their probationary period. And it's such a short period of time to get to know somebody to find out whether they are suitable to you. This is going to have a ripple effect on lots and lots of things that we do. And I want you to make sure that you are prepared for that. There's no point waiting until July to see this in place. You might as well start these habits now. And then in 12 months' time, you'll thank yourself that any risk of anybody being found to have been unfairly dismissed is very unlikely because you've done everything correctly. You've done everything right. This is going to be primary legislation. So a lot of what's changing is secondary legislation. It's small, minor changes, and therefore quite easy for a future government to come along and say, we don't want to do that anymore. And we're seeing a lot of that around the trade union rules that are changing. Some of those are going to be changing 2 months from the inception of the Employment Rights Act receiving royal assent, so mid-February. The minor changes because it's secondary legislation. Primary legislation is harder for this to be revisited in the future. It would be resulting in something being repealed, so it's much more difficult. And therefore, I think it's going to be much more imperative that we get this right, because if the government changes after a 5-year term in office or less, this isn't going to be the first thing that they're going to be able to change if they're a different colour to the government we have today. The government is also going to not just fiddle around with unfair dismissal claims and how long somebody needs to be employed with you in order to claim unfair dismissal. It's also going to remove the cap on unfair dismissal. And I did a video about this over Christmas that will be coming out very soon. I don't want to repeat myself this evening, but basically what we're saying is that there are people in society for whom it made no sense, no matter how unfairly they've been dismissed, to bring a claim. So for an example, talk about football managers. Some of them have been unfairly dismissed, the way they've been treated, the way their case has been dealt with, the sort of the payments they've received to walk away from their job. If you've got somebody on big bucks, and let's just say that football managers tend to be on big bucks, it made no sense for reputational damage reasons. Nobody wants to hire a football manager that's took somebody to tribunal, for them to bring a claim to receive £118,000 and some shrapnel. It made no sense. However, by the government removing the cap of a year's salary, 52 weeks, or £118,223, those people who've got multi-million pound deals are going to be likely to bring claims for unfair dismissal. So I'm not really quite sure what the government is after with removing the cap on unfair dismissal claims, because as I keep saying, ACAS is on its knees, and this is only going to make matters worse, because some high-profile cases, some very well-paid people are going to concern themselves that they've been unfairly dismissed, and rather than them perhaps deciding to, take the money and walk, they're going to bring claims to make their feelings known. We've had people fired from the BBC, they've lost their shows, they've lost their contracts. They were on big bucks, they were on £1 million deal pluses. Will they now say, right, I'll see the BBC in tribunal, I'll see them in court for unfair dismissal? This doesn't help anybody if the tribunal service is going to get clogged up with these claims, with people who were on good money bringing claims that wouldn't have previously brought those claims. So this is an interesting area. And also, I think it's going to change people's attitude towards perhaps settlements. Another area that I covered in my video was, the older worker for whom they might have thought, my only option is to claim that I've been unfairly dismissed on the grounds of my age. So age discrimination. They won't need the service if they're dismissed in the future, because that's gone down to 6 months rather than 2 years. They won't need to necessarily claim age discrimination. If they were on a good salary when they were dismissed, they could now get more money in terms of their pension, in terms of their what they would have earned in their compensation could have been much greater, because it could go up to them saying, well, I was in my early 60s when I was fired unfairly, and I intended to work until my mid-70s. Nobody's going to be able to challenge that, because that's down to the individual's decision. So if they can convince a tribunal that they were due 10 years pay, 10 years pension contribution, all of that lovely stuff, again, could be much higher a claim than £118,223. So I think we're going to see some real changes now that this is something they want to do. Again, I can't see what objective they're trying to achieve, because it was £118,223 or 52 weeks, whichever was lower. I don't understand what they're trying to achieve by removing that cap. So what should we be doing if we're going to get 6 months rather than 2 years? Well, you've got to get super robust with your recruitment. You should anyway. You should improve your contracts to employment, because obviously you do not have the option to be running around with contracts that are out of date. You should make sure you use conditional offer letters. I mean, they should be important anyway, but if somebody hasn't started, service hasn't started, and that's going to be important as well. We do not want you starting the wrong people. So, you know, please don't take the view that you think that you can make that person who's the wrong person the right person, because that don't work out. As we say on our office door, those of you that have recently seen it, we do HR because employing your mate's cousin Dave rarely works out. And it is true. You know, please don't start the wrong people, because it's going to be so much harder for us to get moving those people off your bus and onto someone else's bus. We're going to have to start managing performance from the moment they walk in the door. So my advice will be really beef up your probationary period. Our points of contact in our business that we recommend to our customers is that you catch up with somebody at the end of their first day, at the end of their first week, at the end of their first month, after 3 months, and after 6 months. Whether we will change our guidance on 6 months probationary periods with the law changing, we're up in the air about at the moment. With something we're thinking about, because it may not make sense for you to have a 6 months probationary period if you get 6 months service to bring a claim for unfair dismissal. It may make sense to have a shorter probationary period and know that those people that haven't made the probationary period have left long before they would get the right to bring a claim for unfair dismissal. Watch this space. But as we said before, don't kick the can down the road about variations. Get on with them now. And you can't kick the can down the road about dealing with your problem employee, because come January 27, they don't need that service of 2 years to bring a claim for unfair dismissal. And people will, and they will do in their droves. Bereavement leave. Currently, there's no statutory right to bereavement leave unless you've lost a child, which is covered by the parental bereavement leave regulations. Government intends to introduce bereavement leave of a week, unpaid bereavement leave within 56 days at some point in 2027. This will also include pregnancy loss before 24 weeks. So we will be introducing policies on pregnancy loss to support employees who have suffered miscarriage, I'm afraid, before 24 weeks, which, as you all know, probably on this call, is hugely common. 1 in 4 pregnancies don't make it to 12 weeks. So very, very common. We will require you to update your policies and procedures. We will be introducing pregnancy loss policies into handbooks. Bereavement leave will obviously be a handbook section as well. And the government will consult, we're told, about what that looks like and how best to word it to ensure that obviously bereavement leave is there to support people and not took advantage of. I did read something recently about somebody saying they're starting a new job, which meant that all 4 of their grandparents were now alive again. Very, very cynical. Very, very cynical. Currently, protection against dismissal for people who are on maternity leave or dismissal, is there. Obviously, you can imagine that the reason why we have so much of it of pregnancy being a protected characteristic is there are people who, as soon as they announce they're pregnant, they're shown the door, and because of that, there has to be legislation to protect those people. With redundancy, you have rights when you are on maternity leave that are different from the rights you have when you are pregnant, which seems very strange. So the government wants to streamline all of that and make it unlawful to dismiss pregnant women, women on maternity leave, and those who've returned within 6 months. So government consulting on this, likely to happen in 2027, but protecting women who, I'm afraid, are the victims of discrimination once they've had a baby and when they're pregnant, expecting a baby as well. So very important to bear this in mind for the sector because of so many pregnancies that you see. Sexual harassment. So from October 26, we've got some changes coming here. So sexual harassment will be a breach of whistleblowing regulations from 2026. So minor change, because I haven't yet met an employer who hasn't treated the act of sexual harassment to be a protection under the whistleblowing legislation, because clearly it's a protected act. If that happens, then you've done something unlawful. So therefore, you'd want it to be something that's protected from whistleblowing allegations. If you bring a whistleblowing allegations, protection from losing your job because you've whistleblown. Remember, from October this year, all reasonable steps is what the government expects you to do to prevent sexual harassment in the workplace. Not just reasonable steps, all reasonable steps, much higher bar. And an employer becomes liable for third-party harassment. So third parties could be your parents, your suppliers, your neighbours, anybody who might harass your members of staff that aren't your employees, you will be liable for those acts and to make all reasonable steps to prevent it from happening in the first place. So if you haven't already got yourself an anonymised sexual harassment reporting line, get that in place. We can offer that to you at Redwing, very low fee. But you need to be able to demonstrate you've taken all of these actions. So without an anonymous sexual harassment reporting line, would somebody be able to allege that you haven't done enough? We think they would. You're going to need to think about your policies and procedures. You're going to need to think about your training for managers, training for people who witness sexual harassment in the workplace, to know that they've just seen something they shouldn't have seen because it shouldn't have happened, and how to go about making that matter addressed and dealt with. I think it's so important that we think about this as a priority for 2026 and 2027. Flexible working, again, I wouldn't worry about this one too much because the government has made it very much a minor change. You've got 8 reasons in law to say no to sexual harassment, to flexible working. 8 reasons in law to say no to sexual harassment. That could be interesting. 8 reasons in law to say no to flexible working. Those are still changing. You've been able to make 2 a year for a while now. You've been able to have it as a day one right for a while now. The government wants us to make sure that we write longer letters when we say no to somebody. Okay, not a problem. So if it's going to be a no, it's not just going to be 1 paragraph, it's probably going to be 2. So please don't sweat too much about this one. We are expecting a new ACAS code of practice on flexible working. It's just going to be more involved to say no, but you'll still be able to say no if it doesn't suit the business. The government, I think, sort of trialed this one by talking about making the 4-day week norm. Obviously, that's not going to happen, and it's a minor change from the Employment Rights Act. The right to advise a worker that they can join a union. This is going to be a bit complicated. We're expecting standard paperwork that we have to give new starters and standard paperwork that we have to share with people annually to say that this is what a union is, this is what they would do for you, this is how you can join one. These are some names of some places that you might go and speak to unions about how you might join their union. These are some unions in your area. These are some links and some hyperlinks for you to find out which unions might protect you in particular sectors more than others and have more information about particular sectors more than others. It's more than just a sentence in the contract that says you have the right to join a union. The government wants us to go through some hoops. I'm afraid it's admin at a time when most people are knocking admin on their head, but we will comply with that admin and make sure that our employers are legally compliant. As I said at the start, I think this will make everyone join a union? No. But I think it's what the government intends to happen, is that union membership is normal and common and everybody is joining a union for one reason or another. Wanted to mention about zero-hour contracts. Enough early years employers still use in zero-hour contracts and still want to. Labour have wanted to get shot of zero-hour contracts for many years. They believe that they're exploitative. There are zero-hour contracts that are exploitative. Let's not kid ourselves. There are employers out there that exploit people. However, a lot of people have a zero-hour contract because they want a zero-hour contract. They don't want to be obligated to work 52 weeks a year. They want to be able to choose when they work and when they don't. Maybe they have other commitments around work and they don't want there to be any blurred lines. So do I think the government will be able to remove our right to use zero-hour contracts in this parliament? Not a chance. They want to make guaranteed hours the requirement after someone's been working a certain number of hours for 12 weeks. However, if you take businesses that take on casuals, the last thing they would want is for someone to be offered guaranteed hours after 3 months. That reference period, if you can imagine, if it's over the summer holidays, if it's over busy periods in trading where you do need all the staff in, the idea that Sainsbury's will hire people in October, November, December in order to deal with the run up to Christmas and then not need those people in January, February, March makes perfect sense. But the idea that Labour want to tell Sainsbury's how to run their business and how not to offer people casual contracts because then they'll be guaranteeing those hours in contracts going forward. I can't see it happening. Obviously, we've got zero-hour contracts and zero-hour workers. They can be on less terms and conditions to make them an employee rather than a worker, or the other way around. The idea that something is defined as guaranteed hours, is that guaranteed an hour week that they have, or is it guaranteed that they're not 0 hours? Would that make a difference? Lots of things to think about there, lots of things that require consultation on, and for the definitions to be sort of consulted on, not just the idea to be consulted on. I can't see this happening before 2029. I think it's hugely problematic, and I don't think there's necessarily a lot of support for this. Remember, if you need our support, you can get our help as either a consultancy business or as HR admin or employee referencing. You can speak to us through our Verify details, as well as Redwing Solutions. And if this wasn't bad enough, the government wants to extend the time frame that you'll be able to bring a claim to a tribunal from 6 months, from 3 months to 6 months. At the moment, if somebody is unfairly dismissed today, they've got 3 months less 1 day to bring a claim. In the future, it'll be 6. So if this wasn't bad enough, all that we've just heard, they want to expand the number of claims they receive by giving people a longer window of time to bring that claim. So those well-paid people that I was speaking to you about when I said about the cap being removed, they won't have to make a decision quickly. They'll have longer. So have we got any questions? We've got 5 minutes or so before we wrap up. Let's see if there's any questions. Is paid paternity leave reclaimable as SMP? Nope, it's not reclaimable, I don't believe. If I'm wrong, I'll check it out, but I don't think it's something that you can claim back, SPP. SMP, you get 80%, sorry, 104% back, depending on how big your national insurance bill is, but I don't believe that that's the same for SPP. SSP used to be reclaimable and hasn't been for a long, long time. Another question, SSP tends to be recalculated per day. Will that now be best calculated per hour? Potentially. Do I think that somebody who goes home during the day will be a day one right to SSP? Yeah, potentially they could be. I mean, that's a very good question, actually. I mean, at the moment, as I say, if somebody's on SSP only and they go home at, say, 10 o'clock because they've tried to do work and they can't, would the government then sort of expect you to pay them for the remaining of their shift? The devil will be in the detail there. My inkling is actually that they will say no, that if you lost the whole day, you're eligible for SSP, but not part day. Because again, you know, we start sort of saying that somebody lost 59 minutes of their shift because they couldn't quite make it to the end, then we could really be very pedantic about the amount of money they receive as SSP for that day one right, wouldn't we? So I think the vision the government has is that Betty wakes up at 8 a.m. She should be at work at 9. She ain't going to make it. And rather than receive nothing for her Saturday job, she receives something because it's a day one right. I think that's what they have in mind. I don't think they visualize that situation of somebody going home because they've tried to come to work and they haven't made it, but it'll be worth looking out for. So thank you for asking the question, and we'll definitely have a look. Someone's asking about do you need to implement if the government are removing the lower earnings threshold for SSP, when do we need to implement the 80%? It'll be the same time. So the lower earnings threshold and the day one right to SSP will both come in place in April 2026. I believe it's the 1st of April. Obviously, with it being April, we have to track to see whether it's a tax year thing. So it might be the 6th of April, but we believe it's the 1st of April to make it straightforward for all of April's payroll. The 1st of April will come round, and if somebody is not earning the lower earnings threshold of £123 a week, I think the lower earnings threshold might be 125 from April, then they will be on 80% of their average weekly earnings. So you'll have to go back and look at what an average is, potentially 12 weeks, and use that as the base figure for what their SSP will be. So if they on average earn £90, then it will be 80% of 90, which I think is 72 or thereabouts. Yeah. So yeah, that will be the complicated maths you'll want to math. I'm hoping that Sage, Payroll and QuickBooks will have calculated all of that for you. So the mathing won't be done by you, it will be done by the computer. Thoughts on incentives to encourage people to come to work? Well, again, it's hugely been problematic, hasn't it, to say to people that we give you bonuses if you attend work, primarily because you should attend anyway. So being given a bonus to do what your contract requires you to do never really made any sense. And for some people, obviously, they will have a higher level of sickness absence due to disabilities. And so therefore, would they be victims of discrimination on the grounds of their disability if they didn't receive that bonus and were able to show that they were off for a disability reason. So it's always been hugely problematic. I think what we've got to try and almost do is to, rather than incentivize attendance overtly, we've got to disincentivize non-attendance strongly. So for that, it's things like obviously making sure you do return to work interviews so that regardless of whether somebody thinks they're going to get some pay, was the fact that they attended a return to work interview and were obviously asked about their decision to be off that day, whether it was to protect others from transference of germs, which may well be an honourable reason, or was it be because they didn't want to take any medicine or a tablet to see if that improved how they were feeling. Those sorts of things can be hugely helpful, always been helpful, but will be more helpful if your short-term absenteeism numbers rocket. And something that we're giving a lot of thought to in Redwing is actually the impact of being around other people at work and how that can actually be really good for you. So if you think about, the workplace, and if you are going to be out in nature, when we travelled past some forest schools on the way back from Nottinghamshire today, if you think about how being outside and being with other people that make you feel good and the mood boosting that has on you, is there a link between going to work and actually feeling better than if you stayed at home and you felt worse? So we're looking at seeing whether there's any empirical research on actually that work can make you feel better, and try to encourage people to see work as being not just a source of being paid, but actually being something that's going to improve how you feel, and therefore be good for your mental health and be good for your physical health as well, because it may well be that you're better off if you're in work than you are if you're sat at home considering why you might not be in work today. So that's something we're giving some thought to as well. But watch this space. We'll produce a report on everything we've gathered as being good strategies for incentivizing attendance as well as disincentivizing non-attendance. Jolly good. Any further questions? Yeah, we're going to contact you with any changes, so don't worry. I mean, obviously everything comes around when it's ready, but we will be coming to you to tell you that things need to change. But yeah, hopefully this has given you a flavour of what's going to change this year and giving you some things to think about. So we've just kicked off Operation Respond. You've had your first webinar of 2026. I hope you found that useful. Lovely to see so many of you live, 47 of you. That's amazing on a Monday evening in January. I wish you all a lovely evening. And we will see you tomorrow night, those of you that are joining us live again, when the lovely Jane Todd will be talking to us all things business and funding and how to navigate nursery business life in 2026. So I hope you'll join me tomorrow. If not, we'll catch you on the recording and we'll upload this for your teams and you to rewatch on our Facebook group at some point tomorrow.